Division 1 is now in session.
Morning. This is the time set for oral argument in Linnen against ATP. Our cause number is 1CA CV160029. Counsel, we have reviewed the record, conferenced the case, read the briefs. You may bear that in mind as you begin your presentations. Our proceedings today will be audio and video recorded, and those will be available online shortly to the public. Each side has 20 minutes for oral argument, and the appellant has as much time as you wish for rebuttal, subject to watching your own clock. So if you're prepared, we'll proceed.
Good morning, Your Honors, and may it please the Court. My name is John Egbert. I represent the appellants, ATP and Josh Klein. The law here is pretty simple to state in terms of what is required when to decide arbitrability issues. Normally, arbitrability issues are presumptively decided by the court unless the parties clearly and unmistakably provide otherwise. If they clearly and unmistakably say we're going to delegate that decision making to the arbitrators, then the law is that the courts must enforce that delegation unless one of the parties challenges that delegation provision specifically.
What does that mean? I mean, what happens if, well, first of all, let me ask you in this case, just so I understand it, because it's a little unclear to me. The challenge to the it was an unconscionability challenge.
Right.
They don't have to use magic words, right, of saying, we think that the delegation clause is unconscionable.
No argument.
But what happens if someone comes in and says, Judge, well, what did they say when they said this is that as far as unconscionability, how did they describe what they felt was unconscionable?
Well, what they described was that there are, right now I'm referring to their response to our motion to compel, which is where they should have brought up these arguments.
Or in the motion, it was a motion for reconsideration.
There was a motion for reconsideration, and
Hold on, just so I know.
okay. For example, they said at page 4 of their response to the motion to compel, the flight school agreement and its arbitration clause are unenforceable against Linnen. So that's a situation where they're talking about the entire agreement and the entire arbitration clause within that agreement. No mention, in fact, there's no mention anywhere of the delegation provision. And by that, I'm not saying that they had to say delegation provision or call it that, but they had to point to, make an argument that said the delegation or the giving of the arbitrability issues to the arbitrators was unconscionable because they had to make something like that.
If the argument is it's unconscionable because the whole arbitration clause is unconscionable, is that good enough?
No, it's not. Okay. And that's you can look at the Renner Center case at pages 73 and 74 of the U.S. Decisions. Mm-hmm. And that's the argument that the employee in the Renner Center case made. He said this whole employment agreement and the arbitration clause are unenforceable against me. And the court said, look, you've got to make a argument specific to the delegation provision that's at issue.
Substantively, it doesn't have to say, gee, it's unconscionable for a different reason. As long as they say something that says, argument that specifically the delegation clause is unconscionable.
That's right. It's what isn't good enough, Your Honor, is that you can't say the whole arbitration agreement, including the delegation provision, is unconscionable. Okay, and here what they really focus.
What I understand the Supreme Court has held it, but what's the rationale behind that? They're claiming that the the agreement is unconscionable, but why does it have to specifically address that provision?
Well, it's because the court has made it very clear and emphasized under the Federal Arbitration Act that this is a contractual-driven arrangement. This is what the courts are going to try their best to give effect to what the parties agreed to.
I'm curious. I know what the Supreme Court said, and I know that its opinions are binding on us. How is it ever conscionable to give someone a financial incentive to make a decision? If we got paid more for every remand, who would have faith in the justice system?
Well, I think that's a fair point. But what is most important here is to recognize that the parties agreed that, as between the courts and the arbitrators, they agreed that the arbitrators were the ones that were going to decide these threshold arbitrability issues.
They thought about that agreement?
Pardon me?
Do you think they thought about that agreement?
Well, I don't think that's part of our analysis. I think there's a whole spectrum of possibilities there. None of it's in the record, and I don't think that's part of the analysis, candidly.
Isn't free choice a component, though, of a contractual agreement?
It is, Your Honor, but I mean, we can wax philosophical at a very deep level here about the nature of contracts. But I think what the Supreme Court has tried to do is give a kind of a rational, this is how we're going to deal with when parties come together and they say that arbitrability issues are going to be decided by arbitrators. Here's how we're going to resolve it on a practical level, because we're not going to dive in that deep.
That is what they've said. But I guess my question is really this. So if we accept that you need a specific challenge to the delegation clause, divorce yourself from the facts of this case. Give me a hypothetical argument that would make a delegation clause unenforceable. What kind of challenge would ever be cognizable that wouldn't fundamentally involve the arbitration clause itself?
Plaintiffs come in and say, they presented me with this agreement. I sent them an email that said, hey, I don't get this part that says even enforceability and applicability of these of the arbitration is going to be decided by arbitrators. What does that mean? And ATP sends back a response that lies to them.
Okay, yeah.
There's a fraudulent representation, and they could come in and say, that's not enforceable, Your Honor. That's one example. I think I could come up with others, but there's one that's clearly not applicable. So it's not, and I want to make it clear that what I'm saying is not that if they said that the whole arbitration agreement is unconscionable or unenforceable for some reason, and for that very same reason, that same reason also applies to the specific delegation provision. If they had done that, then arguably that would be good enough. But they hadn't even done that.
Okay, so what's the difference between that and what you said earlier, which was if you said the arbitration clause, including the delegation clause, is unconscionable? That sounds to me like
it does sound a lot the same, Your Honor, and part of that is just communication problems. What I'm trying to say when I said it earlier was simply that, look, if you argue that the entire arbitration clause is unenforceable, that means you're arguing that every part of it, including the delegation clause, is unenforceable. But you're not specifically applying that rationale. You're just saying, look, everything gets thrown out because let me give you a concrete example.
But you don't have to use the magic words, the delegation clause.
You don't. Let me give you a concrete example here. In this case, what they really were complaining about, if you look at their response to the motion to compel, is, hey, it's not fair that we have to go to Georgia. And it's not fair that we have to appear in front of a panel of 3 pilots. Those were the concerns that they had. They never said that, and by the way, those are not part of the delegation provision in this case.
I understand that, but it's the same reason that the arbitration, that's the same argument why the delegation clause is unconscionable, is the same reason the arbitration clause is unconscionable. I don't want to have to appear before plaintiff. Doesn't want to have to go to Georgia to appear before 3 pilots to determine whether this thing is even arbitrable.
Well, doesn't want to doesn't want to and unconscionability are two different things.
Says it's unconscionable even to have this whole thing sent over there, but doesn't have to, and I'm dealing with the waiver, this idea of did they raise it? And, right, because we're not really discussing whether the contract, the effect of Rent-A-Center on the agreement. It's really the waiver. I mean, this is a subset, the waiver issue. It bothers me that someone can come in, not have to, that the argument seems to be, you don't have to use the magic words, the delegation clause. But somewhere you got to say the arbitration clause, including the delegation clause, is unconscionable. And it seems to me that if you just come in and say everything dealing with the arbitration clause is unconscionable for the same reason, why that doesn't sufficiently raise the issue.
Well, I think it's because we're going to, the Supreme Court, in trying to figure out how we're going to resolve these kinds of cases with dealing with arbitrability and delegation provisions, has tipped the balance in favor of, unless you do more than simply say the entire arbitration clause, including the delegation, then that's not enough. And so you've got to draw a line somewhere. And that's exactly, Your Honor, again, I would point out that in Rent-A-Center, that they challenged that the, quote, the entire arbitration agreement, comma, including the delegation clause, comma, was unconscionable. That was one of the arguments that the employee in Rent-A-Center made in response to the motion to compel.
That's insufficient.
Court said that's not enough.
You don't have to use the magic, but I don't understand.
You don't have to use magic language, but you do.
You don't have to use the magic language, but if you just say the arbitration clause with the delegation clause, I don't know where you draw the line on that.
Well, I think where you draw the line is you have to say something like the delegation provision is unconscionable because of X, Y, or Z.
And then you then say, oh, and by the way, the arbitration clause is
For the same
unconscionable
reason.
because of A, B, and C.
You could say that.
So
Yep.
if the argument that you present that the arbitration, the contract is unconscionable, if it, as articulated, would apply to the delegation clause, is that enough?
I don't think it is under the case law that of Rent-A-Center, Brennan versus Opus Bank, and the other cases from the Ninth Circuit that have relied, and district court cases, by the way, have now, there's plenty of cases we can look at there too, and they all support that notion.
What if the plaintiff had said, look, pilots know a whole lot about flying, but they don't know anything about contract interpretation or unconscionability, so the court should really decide this because pilots are just the wrong people. Would that have been good enough?
Yeah, I think if they, because that's an argument that suggests, I'm not sure it's a winning argument, but it's an argument that would go to, and that's something that the court would have to decide before sending it off to the arbitrator. Didn't happen here.
Or not sending it off to the arbitrator.
Or not sending it off if they decide that it's a winning argument.
Right.
Right.
Okay.
Is the purpose of this, I mean, it still doesn't make any sense to me. I have to tell you, in all respect, Justice Scalia wrote the.
He did, right, Rent-A-Center.
And, so I don't know what his original intent was. But it does seem to me to be sort of not very helpful to have saying, you don't have to use magic words, but you have to specifically say the delegation clause is unconscionable. It seems to me that what makes sense in that is simply you want to alert the court to say you shouldn't decide whether this is unconscionable or not. The delegation, because the delegation, you have to decide whether because you can't decide whether the arbitration clause is unconscionable because the delegation clause says it has to go to the arbitrators, and that's unconscionable. It seemed to me to make sense that way, but so the judge is sort of alerted that I shouldn't even be deciding unconscionability because it has to go, unless I find the delegation clause is unconscionable, it has to go to the arbitrators to determine arbitrability.
Well, Judge Kessler, here's the problem that the court has said that, and this is long before Rent-A-Center, they got to this point saying that, look, just a general about the whole arbitration clause being unconscionable, if you have a delegation provision, that's not good enough. So and the reason for that is that the parties agreed that even that unconscionability argument is going to get decided by the arbitrator. So they're really wanting to hew in favor of getting it to the arbitrators like the parties agreed. And so
as long as you alert the judge to saying you shouldn't even be deciding whether this agreement's unconscionable, because the delegation clause, which is conscionable, conscionable or unconscionable, says the arbitrator shall do it. That seems to me to make sense, but not, gee, you got to say something about the delegation clause, but you don't have to use the magic language.
Well, but I thought I'm a little bit confused now, because I thought what your example of what you thought made sense was the party bringing to the attention of the judge that there may be a problem with the delegation provision. So I agree with that.
Okay, but they don't have to, but it's, the problem with me is, but the court's also saying, but you don't have to use the magic language.
Okay.
So
Well, I think that simply means that you don't have to call it the delegation provision, but you have to point to that provision without calling it that.
Does that make sense to you?
It makes sense to me.
Does it?
It really does.
All right.
Because,
What did they do here?
pardon me?
In the response to the motion to require arbitration, they argued that the arbitration provision was unconscionable, right?
The entire agreement, the flight school agreement, and including the arbitration
Was unconscionable.
was
Don't say
unconscionable.
anything about delegation clause.
Did not say
They
anything
don't
about
reference it saying anything else. And then in the motion for reconsideration, they do say, by the way, the delegation clause is also unconscionable.
No, they don't do that. Here's what they say at page 5, lines 9 through 16, is the closest they come. And there they say, therefore, Linnen specifically challenged, now they're talking about what they had already done. They're trying to characterize what they had already done. Therefore, Linnen specifically challenged all aspects of the arbitration agreement, including the delegation clause.
And Renner Center says that's not good enough.
Right. So they don't say the delegation clause or point to that language and say that's problematic. I have 4 minutes left. If it's okay, I'd like to reserve the rest.
Very well.
Thank you.
Good morning. May it please the court. My name is Timothy McCullough. I represent Thomas Linnen in this matter. Mr. Linnen is here with us today. He is actually now just about to become a line pilot for SkyWest Airlines. He managed to overcome him being unceremoniously removed from the ATP flight program, and he is doing quite well, which is sometimes in these proceedings we see people who have been profoundly affected by them. It's good to see somebody who's doing well. I listened to the very, very technical arguments made by ATP with respect to this delegation clause, and what I want to point out to the court is, I don't think the court needs to get to the unconscionability. I think if you look at ATP's initial motion to compel arbitration, what didn't they ask the court to do? They never asked the court, hey, court, there's this delegation provision that's in there.
But it's not their burden to challenge their own provision.
But if you read Rent-A-Center, and if we read Rent-A-Center, we look at Judge Scalia's language, and also keep in mind with Rent-A-Center, in Rent-A-Center specifically stated in their motion to compel arbitration, district court, the issue of whether this is unconscionable or valid or enforceable has to go to the arbitrator.
But do they have to do, I mean, if all they're saying is, Judge, if ATP or Renner Center comes in and says, Judge, we have an arbitration provision. That's and we want this case to be dismissed or stayed so it can go to arbitration. Why do they have to anticipate every argument that the plaintiff might make to say, no, Judge, don't do that? They can wait till their reply, see if he raises it. What happens if the plaintiff says, I'm not going to challenge the arbitration provisions being unconscionable? So are you saying that the ATP would have to anticipate that argument and say, here's why it's enforceable?
I do.
In its motion? Really?
I do, and here's why. If you read the Rent-A-Center decision, and Judge Scalia clarifies it this way, and I'm using his exact language, an agreement to arbitrate a gateway issue is simply an additional antecedent agreement the party seeking arbitration asked the federal court to enforce. And the FAA operates on this additional arbitration agreement just as it does any other. I read the Rent-A-Center decision as being, Rent-A-Center said, please enforce this delegation
But
agreement.
why would it have
And-
to? Who cares about the delegation agreement until somebody challenges the delegation? If there's an arbitration agreement, there is no question as to arbitrability posed until somebody challenges arbitrability. So why would you have to make an argument about something that may not even be in dispute?
Because Judge Swan, if it's an antecedent and a separate, the way the Rent-A-Center reads, it's a separate part of the agreement where a piece of the agreement is, hey, we have to go arbitrate and determine issues of arbitrability in
They
Georgia.
might also
But
have
if
a separate agreement that says you have to wear a blue uniform, but that's not at issue. What's at issue is the arbitration clause itself. And the arbitrability may become at issue if somebody says this is unconscionable, this makes no sense, and I might very well agree that the arbitration makes no sense. But unless somebody raises that, why would you have to argue about every term of the contract that may not come into play?
Because if you have a clause in a contract that you want a court to enforce, I think you need to go to that court and say, hey, enforce this part of the agreement. You don't take
Just
the
enforce
under. I'm sorry.
If it's just a contract, and I go into a court and I say, Judge, I have this contract, whatever the contract is, and they breached it. This was just a trained commercial. Do I have to anticipate every affirmative defense that they may raise, just in case? All I have to do is say, I had a contract, they breached it. It's then up to the defendant to come in and say, well, wait a second, that contract's not enforceable. And then I get in my reply to address that. It seems to me the same reasoning applies here. They come in, the person who's trying to seek to enforce the arbitration agreement, and just says, we have an arbitration agreement, period. Just enforce it. Any defense to that, whether it be fraud in the inducement, whether it be unconscionable, either by procedurally or substantively unconscionable, is up to the defendant, up to the plaintiff to then raise and say, well, wait a second. Don't enforce this arbitration agreement because it's unconscionable or it's illegal or it violates public policy. And then, in the reply, the person seeking to enforce, in ATP, enforce the arbitration agreement can reply to it. You seem to be putting, in fairness, if I understand your argument, sort of putting the cart before the horse and say, well, that requires, that Rent-A-Center requires the person seeking to enforce the arbitration agreement to anticipate anything that might challenge the arbitration agreement and say so in their motion.
I'm not saying that at all. What I'm saying is, under Rent-A-Center, the delegation of the arbitration is a separate antecedent agreement with respect to the arbitration. And if you are the party seeking to enforce the arbitration agreement, you go to the court and you say, Your Honor, the threshold gateway issue is not whether anything with respect to this. The initial threshold issue we're facing here today is the determination of whether we're going to arbitration or not properly before this court. We argue that it's delegated to the arbitrator. They failed to do that completely in the motion.
But your argument would have far-ranging effect and render deniable virtually every motion to enforce an arbitration clause that's been filed since Rent-A-Center. Is there any case that interprets Rent-A-Center the way you do?
And there is, Your Honor. I believe that argument, and unfortunately, it was not in our brief. But if you look at the case of, it is called C.J. Mercandante v. XE Services, and it is a United States District Court case in the District of Columbia. And it says, in there it says,
Citation for that case?
Yes, I do, Your Honor. And the citation is 864 F. Sup. 2D 54. Again, 864 F. Sup. 2D 54. It's a May 22nd, 2012 case.
Okay.
And that case specifically said, and the court starts, but there is an important difference between Rent-A-Center and this case. the defendant in Rent-A-Center specifically and unambiguously sought enforcement of the delegation agreement in its opening memorandum before the district court. Therefore, when the plaintiff, and there's some cites in there, therefore, when the plaintiff admitted, and here the cite is 56 is the page. Therefore, when the plaintiff admitted any challenge specific to the delegation agreement in his opposition to the motion to compel, and first sought to challenge the delegation on appeal, the Supreme Court found that it was raised too late and refused to consider it. Here, in sharp contrast, the defendant's opening memorandum does not even mention the delegation agreement. That's the case here. Or, let alone seek its enforcement. Indeed, in their opening memorandum, defendants present the question of arbitrarily if it is an issue for this court, not the arbitrator. As a result, plaintiffs were never put on notice that in their opposition they might need to address the enforceability of the delegation agreement.
That sounds like that case, and I have not read it because it wasn't cited in your brief, but that case sounds like about an issue of waiver. That the court's saying if the party seeking to enforce the arbitration agreement doesn't raise the delegation clause, then if the party saying the whole arbitration agreement's unenforceable, it doesn't have to specifically address the delegation clause.
And, Your Honor, I don't think it eviscerates all the line of holdings, because all the lines of holdings required that the person seeking to have the arbitrator make the delegability decision initially open, and I don't think that's a hard burden, especially to put on ATP, who crafted this as already a contract of adhesion. They clearly know about it. If you look in their opening brief, they talk about ATP v. Sachs, the mid-air collision where they enforced the delegability clause. They clearly knew it was in there, but for whatever reason, they chose not in their opening brief to mention it at all. In fact, they really didn't mention it and contest it except on a motion for reconsideration. That's when they first raised the issue, to which we responded, and to which Judge Broadman said, you know, there's really not, I think Judge Broadman was thinking, there's really not much of a distinction of a difference to actually go, as you point out, Judge Klesser, to go to Georgia, have to get a 3-judge panel, have to bring them in and have them make the initial decision on arbitrability, whether they're actually going to arbitrate the case, and as pointed out, there's a financial incentive for them to keep the case. But if they failed to ask that it be delegated, and instead they put it in front of the judge. And by the way, when they put it in front of the judge, they made certain arguments. They argued that the Federal Arbitration Act mandated that the court send the matter to arbitration, cited to 9 U.S.C. 2, 9 U.S.C. 3. They argued that federal substantive law governs the question of arbitrability and invoked case law regarding the court weighing any doubts. They argued to the extent that Arizona law governed that it required sending the matter to arbitration. They argued that it wasn't ambiguous. They argued the breadth of the arbitration clause. What they didn't argue, they didn't say, Judge, you don't even get to look at this, and therefore they waived. Then, procedurally and properly, they sort of raise it up in the reply, which is, if they didn't bring it in their motion to respond, to my mind.
So you're turning the waiver argument against them, saying they had the duty to raise this, the delegation clause, and say, no, Judge, you don't even get to decide this arbitrability because of the delegation clause in their motion.
Sure. It's the antecedent agreement. Mm-hmm. It's the gateway issue.
I'm sorry, is that argument, and I don't have your answering brief in front of me, I could draw it up, but is your argument that they have the burden to raise the delegation clause in their motion in your answering brief?
I would say so. Under Rent-A-Center, under the facts in which Rent-A-Center raised it.
Where is it in the answering brief that you say they had the burden to raise the delegation clause in their motion?
I believe it's in our answering brief. We did make the argument that they utterly failed to raise that issue in the initial.
I'm looking at the Mercedante case that you raised at argument today, and I guess I have two concerns with it. Number one, it doesn't say that it is the obligation of the party seeking to compel arbitration to seek an enforcement of the delegation clause. But number two, the case does an interesting thing, and obviously somebody was doing some very good legal research when they wrote that opinion. But it crawls under the procedural history of Rent-A-Center to justify Rent-A-Center's ruling in a way that Justice Scalia did not. I don't know that we have that freedom. Aren't we stuck with what Justice Scalia wrote? Whether his reasoning may have been premised on some procedural fact that's not included in the opinion or not, I'm not sure that type of judicial methodology suits this court.
I think that if this Judge Scalia was faced with this, I think Judge Scalia, I would put the argument to him, Your Honor, you specifically said it's a gateway issue. If somebody doesn't raise a gateway issue, they waive it. And to place the burden then upon, we don't know what they are thinking. If they're not going to argue that issue, if somebody is, and arbitration contracts, the law is very clear, arbitration contracts are not above any other contracts. The arbitration clause doesn't rise above any other clause in the contract. If you want the court to do something, you must specifically ask. If you don't specifically ask, does the burden then fall upon the responding party to go, hey, asking party, you didn't ask, we're going to raise this issue? I don't think
so. You're saying that they have the burden to ask the court to enforce a delegation clause so that the arbitrators can decide an issue that hasn't even been raised. That seems grossly inefficient.
Well, what I would state that they have an obligation. I mean, certainly, I don't discount that they could argue the rest of it, but certainly they need to raise, if the burden is upon the challenging party, it certainly should be upon the raising party to say, you know what, court, you shouldn't even decide this. You don't need to decide this because this has been delegated, and I'll quibble with the fact whether the parties agreed here. I mean, this was an agreement shoved in the face of a young college student. I think unconscionability has been determined by the lower court. But it's not a very large burden on a party at all. And in fact, their failure here to actually raise that argument resulted in a motion for reconsideration and additional pleading, and it sort of deprived Judge Broadman of actually dealing with this issue because they didn't raise it in the initial motion. From the responding party's point of view, if a moving party doesn't ask for a specific relief, doesn't ask for specific enforcement of the contract, does it then become the burden on the responding party to figure out what it is they want?
Yeah, they asked for enforcement of the contract. They asked to have it arbitrated. And then it seems that the party opposing that relief has the burden to come up with every single reason that the contract shouldn't be enforced. One of those might be a challenge to the delegation provision. One of them might be unconscionability. And by the way, we might agree with you on unconscionability, but the question is whether we are the right body to decide that.
But I think we're outside of Rent-A-Center, and we're outside the facts of Rent-A-Center. Rent-A-Center specifically raised it, and I believe the facts said that Jackson failed utterly to address the argument at all. That's the way I read Rent-A-Center, is that
You're saying that neither the Superior Court or we have to worry about Rent-A-Center because ATP didn't properly raise that the court had to delegate that to the arbitrators. That's your argument.
And let me draw your attention.
Right?
Correct. That's my argument. Let me draw your attention to Rent-A-Center, in which it said it talked about the agreement provided for arbitration for all past, present, future. Then it also provided, they're talking about the brief that Rent-A-Center filed. It also provided that the arbitrator and not any federal, state, or local court or agency shall have exclusive authority to resolve the dispute. Jackson then opposed that motion, but he never actually contested that. And if you actually read the court's decision, the way that the court does it, let me find the argument here, where it says the district court, and here's why I think Scalia's reasoning. The district court correctly concluded that Jackson, and here I am on page 73, at 73, and it talks about the fact that because nowhere in his opposition did he mention the delegation provision. The fact was that because he failed to challenge it, the validity of the delegation agreement was presumed. If somebody says in an enforcement of a contract, go ahead and enforce the contract, and the responding party makes no challenge to that, no response to that, doesn't come back and say, no, you can't challenge, we're going to challenge that, it's unconscionable to delegate it to Georgia, or the like. I think that's what Rent-A-Center says. But if the moving party doesn't ask for enforcement of that specific provision, it doesn't have that same question of validity. And I think that for the responding party to then raise the issue of its own accord and have to, and by the way, that is sort of in contravention of the rules, because what burden it would impose on the responding party, I've got to raise new arguments allowing a reply to happen, which I'm not going to be able to respond to. That doesn't seem correct as well.
So is this just a burden to raise it? It's not a burden to prove anything. It's just a burden to raise it to the court's attention.
Correct. You have to put it before the court and say, court, you shouldn't even look at this because it's going to the arbitrator. It doesn't even contain the word delegation provision. It simply must say, I would think all it would have to say is the question of whether this is enforceable or not should not be before this court.
But there's no court, there's no decision you can cite that actually says the movement has to do that. You can cite a decision from D.C. that said the movement did do that, but nobody has come out with the rule you're advocating. This would be terra nova in the interpretation of Rent-A-Center with sweeping application.
I think this court would get an opportunity to distinguish Rent-A-Center from the imposition that it has on a responding party when the moving party does nothing to seek enforcement on delegation. And so I think this particular situation, the case at bar, is factually, procedurally distinguishable. And I think Justice Scalia, if he were still with us, would think that would be fair.
Well, then is that, so if there is a burden to raise the issue, then would that explain the language in Rent-A-Center that has to specifically say that the delegation provision is uncomfortable or unenforceable?
I mean, I think they have to raise it to say we are invoking that relief.
Well, no, but because if what you're arguing is true, then that would explain why Rent-A-Center apparently says that they have to make a specific argument regarding the delegation. I
think that's correct, Your Honor. Yes, I think that's correct. I think they specifically have to. They have to raise it. I'm not sure I would agree that they have to go into unconscionability and all the other issues, but I think they do need to ask the court, please enforce this gateway issue. Did I answer your question?
Yes, I think.
Thank you, Your Honor. I see that I'm out of time. If the panel has any other questions, I'd be happy to entertain.
Thank you very much.
Thank you, Your Honor.
A little bit surprised at the turn that the argument took, and certainly don't know anything about the case cited. But it did sound like, from the little part that he read, that in that D.C. District Court case, that it was a situation where the defendant was actually asking the court to decide the arbitrability issue. That's how they presented their motion. That's not our case here. Here, what we did is, in the normal course, we said, we've got an arbitration agreement, please enforce it. Stay or dismiss and send us to arbitration. Counsel says we should have done something more. We should have said, and court, by the way, there's a delegation provision in here, which means you shouldn't even, I think he said, you shouldn't even decide this. Well, there is no this until they come back and say, hey, there's a problem, it's unconscionable, or it exceeds our reasonable expectations, or something before there's a this.
Mr. Egbert?
Yes.
Do you want to, I realize this case wasn't cited in their in their brief. I assume you might want to file something briefly addressing it after you have a chance to look at it?
I would if it means anything to this court, but
Well, I think it was raised. It was raised late. If there's a request, as a matter of due process, I think we'd give you the opportunity to file something. I'm not sure. I think your summary of the case in argument today was correct. From my perspective, at least, I'm not sure I need to do more than read the case. But
Your Honor, that I don't think. I'm sorry, Judge.
This way. Why don't we, if we feel we need a supplemental brief on it?
That would be very helpful for me. I would appreciate that opportunity. And let me just say one other point about that whole concept in the rent-a-center context, because counsel uses some terms like antecedent agreement and the gateway issues, all out of context. The gateway issues are the arbitrability issues. That's what Justice Scalia, and indeed not just Justice Scalia, but the Supreme Court of the United States said were the gateway issues. And the antecedent agreement language was only in part of his analysis where he said, look, this is different because there's one arbitration provision that says all claims arising out of this contract are going to get arbitrated. And then there's a second independent arbitration provision that says, by the way, not only those substantive merit claims, but also the gateway arbitrability claims are also going to get sent to arbitration. So that's when they're talking about the antecedent agreement. That's where that comes in. This isn't a situation where we have to come in and say, Judge, we'd like you to enforce this arbitration agreement. By the way, there's a delegation provision. Just in case they're going to be raising something, you don't get to decide this, because there is no this until they raise it in the first place. They didn't raise it in their response. And at that point in time, the judge should have said, under federal law, I have no choice but to send it to arbitration. These issues aren't decided yet in terms of conscionability. We're simply saying the judge was wrong to decide them. He should have let the arbitrators decide them. Thank you.
all right, thank you. This matter is now under advisement. We will issue a written decision in due course. No further submissions are necessary unless the panel issues an order to that effect, and the court stands adjourned.